afternoon, and we are going to have a very interactive session and a very informative session. We are going to have me as the moderator. Jeffrey Kadu is my name, and I am an associate at AF Mpanga Advocates. We are joined by two very eminent speakers who are deeply knowledgeable on the subject at hand, but also who are deeply aware of the arbitration systems in these two countries. First, we have Mr. Philip Alikar. Mr. Philip Alikar, I hope that's the right pronunciation, is a Ugandan barrister at law with more than 35 years experience. He specializes in international commercial arbitration, and he sits exclusively as an international arbitrator and has rendered dozens of awards. Since 2017, he has represented Uganda in the UNICITRO Working Group 2 and 3. He is the co-author of the Uganda chapter in the World Arbitration Reporter and an author of the Uganda chapter in the ICCA Handbook. I believe he is also, or was also, one of Uganda's representatives at ICSID, but I think he'll shed some more light on that. Additional to Mr. Alikar, we also have Barbara Kiley. Barbara Kiley is a rule of law and dispute resolution practitioner with experience in justice sector reform, access to justice, and legal empowerment. Today, she serves as country manager to the International Development Law Organization in Uganda, where she supports initiatives that strengthen justice institutions, promote inclusive access to justice, and enhance effective dispute resolution mechanisms through policy and regulatory reforms. So as you can tell, we have a very, very well-stacked group of speakers this afternoon, and they're going to tell us from their experience, from what they know, and their practice, what they think of the amendments to the UK Act and what different aspects of it can be borrowed by Uganda to apply to our own act. So this webinar is being live streamed on YouTube. So if anyone cannot join, you can follow it on our YouTube channel, and you can also save it to watch later. It's going to be available. But thank you everyone who has made time to join our webinar this afternoon. So we're done with the introductions, and we'll enter the discussion briefly. Now, why are we having this theme in particular and at this time? As you might be aware, Uganda is in the process of amending of the Arbitration Act, and several changes have already been put in place. We remember the landmark 2025 changes, which saw the dissolution of CADA to become a department within the Ministry of Justice. We have also seen other changes around appointment. We have appointment authority that is now with exclusively with ICAMEC, and different changes. These are running in tandem with the UK, which is also proposing very serious changes to this act. And in the broader scheme, changes that can affect us Uganda, or changes from which we can borrow. So this afternoon, we expect to hear different issues or different aspects that the UK has taken a bold step to undertake, things like third-party funding, third-party interest in that case, filing issues, all of which our speakers are well experienced and able to talk about authoritatively. I believe to get us started off quickly, I'll just start with a question to both of our speakers. And we will borrow from around the world, because we see that arbitration laws around the world are being visited to keep up pace with the needs of the modern world and commerce. So why do you think this moment of reform in the UK also calls for reform in Uganda, and also more broadly for Africa as a whole? I think I'll start with Philip.
Jeffrey, thank you very much indeed. It's an honor and a privilege to be asked to contribute to today's discussion. Had I known that it was going to be recorded, I might have reconsidered my decision. Google never forgets. But anyway, here we are. And of course, it's always a pleasure to see Barbara, who's a long-standing friend and colleague of mine. You know, I have a real pet peeve about our statute and how it fits into the scheme of international arbitration. And those that have perhaps seen me speak before will know that I have a big beef with the Arbitration and Conciliation Act in Uganda on many levels. But I know this is something that Barbara is going to deal with, so I don't want to spend very long about it. I have in the World Arbitration Report that you mentioned, Jeffrey, that I co-author, mentioned some of the fundamental problems with the Act. Some of them are just printing issues that have never been regularized, but that remain to be regularized. But more broadly, there is a concern that I have with the overall nature of the Act. And I'll park these just for the moment because we will come back to them in the discussion. But I think fundamentally, I think that Uganda needs a completely new statute dealing with arbitration. There is much, much more aligned to the UNCITRAL model law. Now, just so there may be people on this webcast who don't know what the UNCITRAL model law is. I mean, the United Nations sits as a group of states, and they debate and consider the legal infrastructure for international arbitration. That's what produces the UNCITRAL model law. It's produced the Singapore Convention, it produced the Mauritius Convention, and so on and so forth. And the work is done in the working groups, which is where I have been representing Uganda in working groups 2 and 3. And so this is the important part of where business is done. But fundamentally, we need to sit and we need to rethink Uganda's legislation much more along the lines of the UNCITRAL model law. I'll just briefly finish this answer to this question by saying yesterday I met with an English a colleague of mine, Casey, who writes on the English Act, and he too has issues with the English Act. So the problems that we have and the concerns that we have are not just typical to us. They are shared across the international arbitration community, including the English Act, which is held up as the gold standard for international arbitration statutes. I'll stop there and say it's time to try to bring about cohesion and improve and update the legislation. Thank you very much indeed, Jeffrey.
Thank you very much for that very robust introduction. Barbara, you have the floor.
Thank you, Jeffrey. And it's always a tough act to follow when I have to be behind Philip. But just to say, this season is a very important conversation because this has been discussed severally, and I'm hoping that after today's discussion, we actually take forward the recommendations and push through with the reform agenda. Because in Uganda, the conversation has been happening before. It's not like this is the first time we're talking about reforms. The Law Reform Commission began presenting options for updating the Arbitration and Conciliation Act, which I hope I can refer to it as ACA. And the conversation has been important because right now we are following on from the ADR policy reform process that was just finalized and adopted by the Parliament of Uganda, the 10th Parliament of Uganda. So this is the time to actually consider how to move forward the reform process. So the regional context is important to situate ourselves and say, okay, where are we? Especially considering that the Ugandan Act was based on the model law, but it was not updated after the 2006 amendment. So it's important that we look at where are we right now? What can we do to improve the environment for enforcing or recognizing or undertaking arbitration processes? So when you look at the regional context, you not only look at the UK, I think it's important that we look at even those that are close to us. So we have Nigeria to look at, which modernized its Arbitration and Mediation Act in 2023, that introduced various reforms on emergency arbitration, interim measures, so on and so forth. You also have Tanzania, and you have the Kenyan Act, or rather the bill that Kenya is trying to have passed through that is going to reform its process. So this is actually important for Uganda to consider because we have already started the steps. The Law Reform Commission gave their report. The ADR policy has been published. it is now time for Uganda to take forward the next step and review its Arbitration and Conciliation Act and make it as progressive and responsive to the needs of justice seekers. So back to you, Jeffrey, so that we can get on with the discussion.
I like what you've mentioned on the need to make it up to date, to bring it up to date to meet the demands of commerce today. I know, maybe you can guide us. So what prompted the Law Commission of the UK to review the Act, and why now? Why, after 1996, it's 30 years later, why is the need for change more prominent right now? Philip?
Thank you, Jeffrey, for that question. The legal business in the United Kingdom is worth more than £10 billion to this economy. It makes a huge contribution. The work of English lawyers all over the world and the number of disputes that are brought to London to be resolved is significant. And London wants to retain its coveted position as one of the preferred seats for arbitration in the world. So you have London, you have Paris, and to a lesser extent internationally, you have New York. But London and Paris predominantly are the leaders. You have Singapore, which is another big regional center. But London wants to retain that position. And London understands that unless it moves, unless it adapts, and unless the legislation adapts, unless the legislation becomes more predictable, and we'll talk about the various changes and the impact that those changes are intended to have. But it's all about consolidating position. That means improving efficiency and reducing cost. And what we'll see when we deal with these questions and the changes that were introduced by the 2025 Act and the amendments, you'll see that they were all geared towards efficiency, improving efficiency, and driving down costs. What you must also understand is a point that I just adverted to previously, which is that, excuse me, there are vested interests within the arbitration community here. And I do know that there's a group of people, practitioners, who didn't want a radical change to the 1996 Act. So there was actually resistance to doing a more wide-scale, more wholesale change. I mentioned to you when I answered the previous question that I was talking to a colleague of mine who believes actually they should have gone further. So there's this debate that's going on. But for the moment, the compromise that has been found is the amendments that we see today. Thank you.
Just staying with you, Philip. What are the key amendments? What stands out for you from this act? What new inclusions specifically do you think jumped out at you almost immediately?
Well, I mean, the big one for me was the question of determining the seat in the applicable law, which is a technically interesting and challenging decision, which arises out of the Chubb case, the Incat and Inca and Chubb case. There was also the question of summary judgment, which I found particularly interesting. There are other loose ends like jurisdiction, impartiality, and independence of arbitrators. But all of this, as I say, was intended to bring about a saving in costs. I don't know to what extent you might want me to delve into this question about the seat, but I was looking at the decision of Mr. Justice Mubiru and the ATC case, where you had two respondents in that appeal that was before the judge in relation to concerns about that award. In the end, it was set aside, and it was set aside on the basis of the lack of a potential bias of the arbitrator. But at the very beginning of that award, you'll actually see the judge referring to the parties agreeing between themselves to actually change the seat of the arbitrations from Paris. It was London and I think it was London and Kampala, and the other one was Paris. And they changed them all to both to Uganda arbitration with Uganda seats. And that was all because of the applicable law. And that's why the law is so applicable. So in any arbitration, just so everybody understands, in any arbitration, you can have potentially 3, sometimes even 4 laws that apply. You've got the law of the arbitration, or law of the contract, or the matrix agreement, and you'll know, everybody will be familiar with the law of the contract. in the governing law clause. But what we must also remember is that the arbitration agreement is a separable agreement. And separability is a concomitant aspect to this competens, and the tribunal having jurisdiction, even where it doesn't have jurisdiction. So it's a fiction that's adopted to ensure that the tribunal has the power and is seized of the authority, the jurisdiction to decide. That agreement can be governed by a different law. And there isn't necessarily the same, and in fact, there hasn't been the same approach across the world in the different jurisdictions in relation to whether or not the law of the arbitration agreement is the same as the law of the contract. And then there's the procedural law that will apply to the arbitration. And sometimes, of course, in the place of the arbitration, and this is the fourth one, there might be mandatory provisions that apply, no matter what the parties provide for. For example, in English law, there are mandatory provisions that apply. So whether or not you've got the matrix agreement that provides for the law of, Timbuktu or Mali, as it would be, and the arbitration agreement, the law of Morocco, you've still got the question of those provisions of the English Act that would apply if the arbitration happens to be in London with a London seat. So yes, that for me was a really, really interesting point. And again, because of this debate and because there was so much money that was being spent by parties arguing this issue, the English courts, or the English legislature decided that they would legislate to ensure that this wasn't a point of contention anymore. And so London, again, is trying to clear up, and we'll leave it to other places like, the Holland and New York and Paris to deal with the problem, which they continue to have. Thank you very much indeed. Thanks.
Before I let you go, and I'm coming back to Barbara,
yes.
You've mentioned the summary judgment issue.
Yes.
That is totally alien to the Ugandan practice, I will be honest. So
yes.
As someone with experience in the UK, how does that work in practice, and how exactly is it being implemented, and what problem does it serve to solve?
Yeah, I mean, Jeffrey, thank you again for that question. There's a lot in this, and I'm just thinking about the time and so on and so forth. But you're absolutely right. I mean, all arbitrators are concerned about ensuring that each party has a fair opportunity to put its case. That's one of the hallmarks of arbitration. Similarly, the parties themselves want the opportunity to ensure that they can run their own case. However, sometimes parties run very, very unmeritorious points, but there's always a reluctance to summarily determine the case, and arbitrators and parties incur huge expense. The Attorney General, the former Attorney General in Uganda, has complained about this, about parties just pleading anything for the sake of pleading, even when it doesn't have legs, even though when it doesn't have any merit, and incurring huge costs in dealing with these points. What this does is effectively it means that if a person brings a claim in the United Kingdom, and it's considered to be unmeritorious, it's open to the other party to apply for a summary determination of the issues, which cuts down on costs, cuts down on delay, which are the two main areas that they were trying to deal with. As to how it's sort of panning out, I think it's still too soon to say how it's going to work. I have not had any experience yet of anybody making an application for summary judgment in relation to an issue. There are rules like the LCIA rules that provide for a summary determination, but that's not quite the same thing as a summary judgment. And in any case, arbitrators are still reluctant, or previously, before the passing of the legislation, they were reluctant to take that step because they don't want to be accused of bringing themselves within one of the provisions of the New York Convention, challenging for not giving the party a fair opportunity to consider the case. So that's the importance of that. Thank you.
Yeah, I can definitely see that dilemma coming. So it would be something quite interesting to keep our eyes on, how the London Act works vis-a-vis the New York Convention. I think, Barbara, just to come to you, which of these amendments jumped out to you? Just to tell us which caught your mind and why, and maybe you can just guide us on which particular provisions in the changes in the amendment you think were most significant.
I think for me was the emergency arbitration, because in principle, for Kenya and Uganda, we do have challenges when it comes to what we would call as partial or interim awards, because both laws talk about awards, and an award needs to be final. So when it came to partial or interim awards, there was always confusion on how to go about it. So for me, the inclusion of that, and even in the Nigerian Act, by the way, makes it very, very interesting for me and something to watch for, because I think it is likely to strengthen the arbitration practice, because sometimes you're always in that dilemma when the dispute has arisen before you can actually, and the time between which you can appoint an arbitrator or form a tribunal for it to be functional. So there are times you need emergency arbitrator proceedings. So by going forward and providing for that, I think that is quite interesting. I can't wait to see how that will be interpreted. And I wonder whether Uganda will be looking at that, because Kenya has noted that in their bill, and Tanzania has included it in the act as one of the measures that the court can actually provide. So normally I know majority of the practitioners would go for the Mareva proceedings or interim measures, filing a case under certificate. But if you're able to actually get an expert to give you a determination that can then be enforced as between the parties, I believe that that is something very significant. And that is what has jumped out to me. Back to you, Jeffrey.
Thank you very much, Barbara. I think emergency arbitration is a big one. I know there's some work that has been done in Nigeria as well, Kenya, Uganda. So it's really an emerging issue that cuts across jurisdictions, and it's good that the UK has taken such a bold step. I think maybe we can just hear from Philip, from his practice, how the reforms specifically on emergency arbitration and interim measures, how significant those are in terms of practice, or in the practice of law in the UK. How these new changes on emergency arbitration and interim measures counter against what is being done. Philip, we cannot hear you.
I was muted.
Yes,
Yeah, I was. Thank you very much indeed for that question. I mean, Barbara makes an excellent point about the emergency powers of the arbitrator, and actually looking at that and thinking, she makes absolutely the right point that if you can get an early determination, you know, on, say, on a well, it depends. You know, it's the American cyanamide test. It's the interlocutory stage, a determination. Sometimes that can have a determinative effect on a dispute, and it certainly allows. Fills that lacuna, that gap, where previously one had to go to court. But again, you know, with the emergency arbitrators, I'm not yet really seeing this played out in to a great extent. I think people are still, for the time being, and I just say this from experience. It may be completely wrong. I may have no visibility, and the problem, of course, with arbitration is that it's confidential. And unless you're going to have a challenge from an emergency arbitrator, which then becomes an award, it's not necessarily going to work its way into the public domain. But my view is that it allows for the emergency arbitrator to have authority in circumstances where, for example, a party who is on the receiving end, a respondent, who doesn't want to respond, who's being particularly difficult, there's been no appointment and all this sort of business, the formalities haven't been dealt with. It allows and gives the arbitrator much more power, much more authority, which is recognized in statute, to actually make the orders that are necessary to be made in the very, very early stages of an arbitration, where there's an arbitration agreement. And I think that that's a big change, because it then also gets parties to moderate their conduct, because people will know that that they must comply ultimately with the arbitration agreement. But again, the English courts have been really, really good about this in terms of supporting arbitral proceedings. So I think in this jurisdiction, it's probably only likely to validate the jurisdiction of the arbitral tribunal. But I don't see it as having a fundamental change in the way that practitioners approach their work. It's either an application to court in the old style way, or it's an application now for an emergency arbitrator, the appointment of emergency arbitrator, and the emergency arbitrator to then make his or her interim award. Thank you.
You raise a very critical issue on the tribunal, and how this is going to affect the tribunal. Maybe beyond just summary and emergency arbitration, looking at the amendments as a whole,
yes,
what changes have they brought about? The relationship between the courts, the tribunal, you've hinted on the challenges and that a party might have to file an application. So how have the amendments affected the relationship between the tribunal and courts in cases of challenges?
Well, I don't really think, Jeffrey, that the challenges, I don't really, nothing has occurred to me that deals with challenges. I mean, there's a question of jurisdiction. There's the jurisdiction point amendment that that was made in relation to jurisdiction, which provides essentially it's section 32(1)(a) of the amended act. But that really dealt with the questions about competence, and about powers. Because, for example, if an arbitrator decided, or an arbitral tribunal decided that it didn't have jurisdiction, then what jurisdiction does it have to make cost orders? You know, for example, I mean, you can't say I have no jurisdiction, but I can make a jurisdiction. Well, that's gone now because, of course, the competence has been extended to including making orders that are certainly in relation to costs that are binding, notwithstanding the tribunal's finding that it doesn't have jurisdiction. But just generally, the direction of the amendments is very, very pro-arbitration. You know, jurisdiction challenges. I mean, you can still go to court, but there's a priority for the decision of the tribunal if that decision has already been made. Again, that's under the same provision of preliminary determined on jurisdiction. Sorry, that was preliminary determined on jurisdiction. I'm just looking for the cost provision. It's under section 61(1)(a). Sorry, section 61(1)(a) is the cost provision, award of costs, and section 32(1)(a) is in relation to the jurisdictional preliminary decisions on preliminary jurisdiction points. So yes, to answer your question, I think we're still out, the jury's still out, waiting to see how this actually changes the relationship between the courts. But the general direction is pro-arbitration. And again, I say the point of the legislation is to enforce and encourage arbitration and strengthen England as an arbitration center. Thank you.
Oh, wonderful. I'm going to go to a question that you will like, but I want to throw it to Barbara, actually, because you've hinted on how you have beef with the Arbitration and Conciliation Act. So, Barbara, when you look at our act, enacted in 2000, just 4 years after the British Act, it was modeled essentially following the Unicitro model law and the Unicitro framework. In your view, how was our act 26 years later? How has it fallen short of solving the problems of practice today? Philip, you can see why that was your question, right?
I would actually prefer to defer to Philip to answer it.
I want to hear your thoughts first.
Knowing very well that he has several issues. But I'll look at it this way. We are talking about a 26-year-old act and examining it against the current context that we are in. So definitely we will say that it has fallen short. So I'll prefer to look at it from a more positive view, where we can now tease out what we need to do to make it more progressive and more responsive to the needs of Ugandans and other foreign and local investors who may need to rely on it. So when you begin by measuring it against the ancestral model law is where now we start to see what we need to do, because from 2006, there are amendments which were not considered in the ACA. So first and foremost, of course, we will need to think about the form of arbitration agreement, which is something that Philip has just talked about. When you look at the amendments that have been done globally by different acts around the world on arbitration, they have introduced new ways of looking at the arbitration agreement and removing just the requirement for it to be written. So this includes also the e-commerce transactions, so your smart contracts, that they can then be defined as forming part and parcel of arbitration agreements. Basically, when you look at, for example, Article 7 of the 2006 amendments, you notice that it gave states two options. The very first option was a very detailed and defined, which described what could be considered as an arbitration agreement. And then there was the other option that simply stated any dispute that arises out of a legal relationship, whether contractual or not. because we all know that our laws of contract have not been updated as progressively as other laws. So in my view, there are a number of issues that we do need to look at because the current act does not address them. And when you look at the act using a literal lens, it makes it very difficult to apply it effectively. And when we also look at Chapter 4A on interim measures of the 2006 of the model law requirements and the preliminary orders, including tribunal-ordered interim measures, this is important because there is room to see how best to incorporate that into the arbitration framework that we have in Uganda. And the most interesting thing is that the Law Reform Commission had already identified all these gaps, and it had recommended several reforms, not just on the arbitration agreements, but even in how we manage institutional and ad hoc arbitration processes, and how to better define the distinction between domestic and international arbitration. And the most interesting feature, which I know Philip will love because Kenyans were brutal to him, arbitrator immunity, which was critical, introducing provisions that secure the arbitrator's immunity, the tribunal's protection, and also just being clear on how interim and preliminary measures can be pursued before the court, what can go before the court. And interestingly, now when I look at the case law that is coming out of court on the question of arbitrability, it's really difficult when you're sitting down and frustrating to see courts trying to decide whether a dispute is arbitrable or not, when this should clearly be the mandate of the tribunal, and them not setting it back to the arbitrator to determine that. Because there are a couple of cases we've seen this year from the High Court where the judges themselves determined that a particular issue is not arbitrable, and therefore they had the mandate to continue with the cases. So those are primarily the issues that we do need to look at and see how best to improve the current act. The 2024 amendments didn't help much because they caused more confusion. These are the ones that rationalized CADA's institutional placement by mainstreaming it into the ministry responsible for justice. But I think whereas that was driven by the government's rationalization policy, it did not consider the reform that had been suggested by the Law Reform Commission. And it also did not consider the lacuna it created by shifting the department, the CADA into being a department and a Ministry of Justice. So it left many of the contractors who, I mean, the people who had used, the users of the CADA's institutional rules and practices in their contracts confused because they did not know how do you go forward. Do you write to the Ministry of Justice? There was no indication of who in the Ministry of Justice was determining the issues that would be addressed by CADA. I love the fact that now the ministry is doing something about it. So there is a department that has been created. It does have a commissioner. So now people can actually get guidance and find solutions to contracts that had included CADA as the institution for administering the disputes for them. But I think there's still a long way to go because there's been questions of whether or not that particular transition then meant that the Ministry of Justice, being a department under the Ministry of Justice, would have confidence or transparency or even the legal authority to carry out administration of disputes. I think for me, an arbitral institution can function within the Ministry of Justice as long as it has clear rules on who it appoints, how it appoints, what rules would be considered for the dispute. So we need to separate that from whether or not it was actually correct to move CADA into the ministry as a department. I think for whatever reason, government already did that, so it's beyond us. The question now, which should be, when we are looking at the ASA Act, do we need to reform it in a way that makes it practical and friendly and raises confidence of the justice seekers? Because when you look at the English Act does not mention a statutory institution for the administration of disputes. It is silent on that. It is up to the parties to choose whichever forum they want to take their disputes to for purposes of administration. So it begs the question, why did Uganda think in 2000 that it was necessary to have an institution that would administer disputes defined in the Act? Because that brought the question that ICAMEC had to respond to in court. And it's really sad when you have institutions being dragged to court to defend their mandate of administering or even handling arbitration disputes. So I think it is now time for us to look seriously at that and see whether do we leave it to the private sector to run with the question of arbitration administration, or should it be a state function where we can have a transparent and an accountable system that can administer disputes for those who choose it and are willing to go before it? Because that should be an option, just like the Nairobi Center for International Arbitration. There is no mandatory provision that you must go to the NCIA. It is left to you at the contract level to determine which of these. And when you look at the different legal frameworks of the countries that are surrounding us, I had mentioned the Nigerian Act. The legal framework and procedure, especially for Nigeria, was modernized in 2023. Tanzania just did theirs in 2020. So there's actually need for us to consider this and take this as an opportunity to provide clearer provisions on seat as a lesson from England, and see whether if there are any confusions between the seat, the venue, and the governing law, then whatever is provided for as a seat then becomes the lex arbitri. Look at confidentiality, competence, which are always issues that are brought up before the court. Discuss representation, interim measures, emergency arbitrator immunity, very important. And once again, going back to the question of arbitrability, how do we define arbitrability before the court? And most importantly, and I'm hoping that Philip can take us through the reasoning between the English restriction of the public policy amendments, because those are critical. I think both the Kenyan Act, save by when you look at the Christ for All case, it is case law that sort of like restricted the application of public policy. And I think it is important that we all sit down and come up with a narrower definition of public policy. So back to you, Jeffrey.
Yeah.
Yes, Philip, maybe now your question of the day really.
Well, can I before you, Jeffrey, before you do, I just wanted to just come back on some of the good points that Barbara has made. Yes. I mean, we as a country have to be grown up about our approach to government. And I can tell you, because I've looked at Hansard and I looked and have studied the debate in the run-up to the enactment of the ACA 2000. And you can see from the discussion that took place between the likes of the Honorable Mayanja Nkangi and Eli Karuhanga, that what was anticipated was some kind of trade association that was going to help to facilitate arbitration and mediation. So the role of CADA was intended to actually be an office, a department within the legal infrastructure to actually support the arbitral process. But what it actually did was it usurped the position of the court and actually became part of government. I mean, which person in their right mind is going to go to arbitration in Uganda and have the arbitral process regulated by a government institution? It's just never, ever going to happen. And for 20 years or more, there was one person sitting as the Director General, I can't remember, Secretary General of CADA, who was deciding challenges, who was making all these decisions that elsewhere repose in the courts. And so the fundamental, from the very beginning, the act was misconceived. It was actually drafted by people, forgive me for saying so, but I'm older than Uganda and I'm entitled to say so, who don't understand and didn't understand what it was that they were trying to do. And actually, I suppose a more generous point is that things have changed. And we now need to have an act that actually meets the requirements, not just of international parties, but also of local parties. Our backlog is just, in the courts is terrible. It needs to have a process that can happen. Now, I just want to say this as well, just by addition. In the United Kingdom, and Jeffrey, you asked this before, how does this work? You have practitioners who practice the law, they see the defects, they recommend the defects to the Law Commission. The Law Commission is chaired by a Court of Appeal judge in England. So you have a link between the practitioners, between the judges, and between the government. They think about what they want to do to ensure that the position of England is preserved. And they make recommendations, and they ask for people to contribute, stakeholders to make a suggestion. And that's how it happens. I wrote to the past Attorney General and said, I can help you, support you on legislation, on arbitration. I still haven't had a response. We've had an election. He's gone. We just need to start taking a much, much more grown-up approach to all of this. And I hope in this process of amendment that the government does listen to practitioners who understand the infrastructure, and that that they defer to them with the greatest respect. Thank you very much.
Okay, so you've hinted on it. You've hinted on several of the issues. I wanted to ask you what exactly, because you've said we need to become grown up, we need to mature in terms of our approach.
Yeah.
What exactly are the gaps that you have seen or that you've experienced, that you have come across, that you think, and maybe some practical solutions you think that can be adopted off the cuff?
Yeah. Okay, Jeffrey, thank you. Fundamentally, the ACA has, for example, it has spelling mistakes in it. It's got references in the Act to centre where it means court and court where it means centre. The rules have been abrogated. The rules have been done away with by the latest. I think is it the fourth or the fifth change by the Uganda Law Reform Commission. But just dealing with simple spelling mistakes that have been on the statute book for 26 years. Can you imagine that we can't get our parliament to pass legislation that simply corrects a spelling mistake? And here we are talking about trying to follow England before we've even grappled with the fundamental question about what is wrong with our statute. So on a very basic level, there's a problem with getting the just basic printing right. But more importantly, it seems to me that we need to ensure that the Uganda Law Reform Commission is adequately resourced, adequately funded, adequately supported, and that it just deals with things in a very progressive way. There was an amendment that was proposed in 2017. There was an amendment that was proposed in a paper in 2021. These were changes proposed by the Law Reform Commission. We had the RAPEX legislation in 2024. We had the amendment. Nothing has changed. I keep talking about these missed opportunities to try and get things right. And obviously somebody in government is not talking to those people that understand. So we just need a complete rethink about how we deal with this and how it's actually administered. Thank you.
Thank you very much. I can tell that the beef is it's not exaggerated at all. So coming back to you, Barbara, so the practicality of it, the experience of parties in court, especially around issues like the delays and interim, how can court intervention come in to fill such gaps? Because when you have practical experiences of people experiencing delays in arbitration or delays in courts through applications, through different, what I term as guerrilla tactics in arbitration, how do you think, or how can court intervention at least help fill some of these gaps?
It's clear the courts have tried, yeah? The courts are generally pro-arbitration, so they do try their best to interpret to try and put themselves in the party's shoes and promote party autonomy by making sure that the contract of the parties is actually implemented. So sometimes when you look at, like, if you look at the ADC case and you look at how long it took between the IA investment case, and when you look at how long it took to go through the different levels of the courts, you could clearly see that the courts getting frustrated at the parties' actions and the interventions that they were taking. So it was evident that court tried to restrict itself, applying Section 9 of the Act, where it kept reminding the parties that court intervention is limited under the Arbitration and Conciliation Act, and therefore trying to make sure that parties understand that particular process. But they cannot stop parties from forever running to court and trying to delay the different processes that are under arbitration, which is why an amendment would be significant, where you clarify that if you're coming to court, that these are the sections you're coming to court on these particular issues. Do not come to court if your issue is not about, for example, arbitrability of the dispute. That should go before the tribunal. So the court would tell you, no, take back your matters and go back to court. So in principle, the courts have tried their best. The Act is not at its best. We can improve on it. We can make it clear that there are certain sections that do need to be enhanced so that we can reduce the dilatory tactics that many of them play. And that could even come, for example, from the review on the definition on the form of an arbitration agreement. So how do we make it comprehensive enough so that people don't start coming back to court to say, this was not included in our arbitration, this does not constitute an arbitration agreement, or this particular arbitration agreement is null and inoperative. I think making it clear from the get-go, from the Act, that this is what would fall ordinarily before the courts would be very useful. And I'm thinking just ensuring that they protect the rights of the powers of the tribunal to determine particular disputes, that could be very helpful. If the amendments to the Act could be clear that for issues that can be determined by the arbitrator, the court shall not deal. So anytime you show up at the court and the court convinces itself from a preliminary review of the proceedings, they can just send you back to the arbitrator. I think that would help, and that would reduce on the question of the delaying tactics. And I know one of the other delaying tactics that many people use is when it comes to setting aside an enforcement of awards, which is basically what has been the bread and butter for majority of the lawyers who are in arbitration practice before courts, because that is where we earn our money, how to try and delay as much as possible the question of setting aside. So Ugandan Act, I think, is almost likely close to the English Act, because it provides for 1 month when it comes to setting aside. The Kenyan Act, unfortunately, does not do that. It gives you 3 months within which to make the application for the setting aside. So that does reduce the ability of parties to come and play games in the court. But then when you look at the grounds for setting aside, I think we could be more polished, if I may call it that. If we are more polished in the definitions of the grounds for setting aside, be more polished, as I said before, on the question of public policy, because at the moment it is very broad. It allows for anything under the sun to be filed as a reason for public policy to set aside the award. So when we polish that, I think we'll be able to reduce on the grounds that people want to use to come to court and delay the enforcement or the recognition of awards. Back to you, Jeffrey.
Thank you very much, Barbara. That was quite a comprehensive answer. Philip, I want to come to you specifically on the issue of enforcement that Barbara has hinted on.
Yes.
It seems it's becoming a recurring issue for award holders.
Yes.
So what do you think that whether domestically or under the New York Convention, what are the usual obstacles that people or parties to an arbitration are facing, and maybe gaps that you think can be introduced to try and reduce those? I know Barbara has already mentioned public policy. That one is, it has become a panacea, so to speak, for everyone. So what other issues do you think are arising at enforcement, and how the law can step in to bridge those?
Yeah. Thank you, Jeffrey. If I can just start with public policy. I mean, public policy is by definition a very wide concept, and it covers an infinite multitude of issues. And I just don't see that it's possible to limit it in any way. You know, it's a bit like the Constitution and the reach of the Constitution. You know, how does one argue that a particular point does not engage a point of the Constitution? I mean, if you're constructive enough and industrious enough, you can come up with an argument that engages public policy or the Constitution, and then that, you know, presents a problem. I mean, a case in point, you've got a lot of people in the English courts at the moment trying to fight jurisdiction points. And what they do is they plead human rights. They plead the African Convention on Human Rights. You get a case that has absolutely no connection. By the way, you're laughing, Jeffrey. At the moment, there's a case involving EPOC and Uganda, which is being challenged in the High Court of London. And the reason why they've accepted jurisdiction is because they've pleaded human rights. This is a case that has nothing to do with, well, nothing to do with England effectively, but the English courts have accepted jurisdiction. Now I know that, you know, that's litigation, but it's that sort of thing. Now again, I'm just going to come back to this decision of Mr. Justice Mubiru. This is the ATC Uganda Limited in Eaton Towers. This was Smile Communications. And you'll see there that the award debtor was very dissatisfied with that award. And basically, they argued absolutely everything and the kitchen sink to set aside that award. And actually, the judge, they argued everything. They argued everything. And the judge, in the end, found in favor and set aside the award on the basis of the arbitrator having a prior close relationship with the lawyers of one party. Now, I'm not going to deal with the facts of that particular case, because I know I'm speaking in a public forum, but I was approached, for example, to sit in an arbitration in Uganda. And whenever I'm approached for an arbitration, I do my conflict checks. I think about who is counsel. I think about who is the parties. I think about all those things, because it's important to be able to tell the parties that you are impartial. Now, this is Halliburton and Chubb, but it's also one of the amendments that's been made in the UK. I was approached by a Ugandan advocate. She said to me, "We're thinking of appointing you." I asked those questions. I said, "I know the advocate on the other side. This is my background with the advocate," and so on and so forth. They went and approached the advocate and said, "Do you know this man called Mr. Ali K?" "Oh, no, I don't know him. He is all right." Now, I mean, this is the sort of behavior that we don't talk about generally in these sorts of seminars. But there are conduct issues, there are behavioral issues, there are ethical issues. If this process of arbitration is intended to work, then we have to have those of us who are, you know, who believe in the process and who want to uphold the process. Now, I won't go on to say anything more about that case, but I then met another lawyer and I shared with him this predicament of the arbitrator in ATC, who incidentally, Mr. Justice Mubiru did the dignity of not mentioning by name. I mean, we probably know in Kampala who the person was, and Barbara has mentioned a case in which I was involved, which I might come to. But Mr. Justice Mubiru did not embarrass that arbitrator. He made it about the facts. And he then set aside the award on the basis of the relationship. But anyway, back to my point about meeting another lawyer. I met another lawyer and I said to him, I said, you know, why would this lawyer or this arbitrator not disclose that he had this close relationship with the firm? And this lawyer said to me, oh, he was about to publish his book. He should have waited until the 90 days was over and then published his book. I mean, you know, that is the attitude towards disclosure and independence and impartiality, because it would have then been too late. But you see my point. your question was, what was your question?
I do, and that's quite an interesting story.
But
So, yes, so the question about enforcement and
yes,
these obstacles that we face, yes.
Yeah. So I beg your pardon. Thank you for reminding me. So, it is important that we stick rigorously to enforcement, and it's really for the courts to use the provisions under the New York Convention, the various gateways, the various provisions that allow for an award to be challenged. But it's all about balance. It's all about the courts being pro-arbitration and supporting the arbitral process and understanding what is and is not a legitimate ground for setting aside an award. But if there are problems with the process, then there are problems with the process. And I'll just finish, actually. I mean, because again, Barbara has mentioned, I was an arbitrator in a case, and it's the only award of mine that's ever been set aside, but it was set aside by a judge. And in that judgment, the judgment of the judge was a cut and paste, copy and paste of the award debtor's documents. Spelling mistakes, typographical errors, all included. I went to a forensic linguist, and I said to a forensic linguist, Professor Malcolm Coulthard from Birmingham University, and I said to him, Professor Coulthard, I said, look, this is a judgment from a judge. This is the award debtor's documents. Are you able to determine that these are not by the provenance, the writer is not the same? He says, obviously. He says, look, anyway, I had actually done a lot of work. Let me cut to the chase. Cut a long story short. The forensic linguist was able to determine that 3,500 words from the award debtor's documents had just been cut and paste. But the real kicker, and there were a number of kickers, but the real kicker was the judge cited an authority of his own in the judgment and referred to himself in the third person as the learned judge. The judgment was signed in the absence of the other parties. It was signed in draft, and I was abused in the judgment. And this is the sort of thing that you can get in some parts. You're laughing. This is what is.
Vincent, I'm so curious. Was this a Ugandan judge?
No.
Oh, it was wow. That would have been a story.
But that was the most disappointing bit. This is from Kenya. Yeah. So that's why arbitrator immunity is important.
Yeah, but this is exactly right. But this is why I say that if judges, and I wasn't going to name the jurisdiction, but if judges behave like that, why is any investor? And people who know me, I sit on the panel. You were talking about ICSID. I was on the ICSID. I was just about to be put on the ICSID panel for ICSID, by the way, by the president of the World Bank, not by Uganda. So I was appointed by the president of ICSID as a person of the highest integrity. And then it's just, you can't work like this. We will never, and I've said this, we will never attract cases unless we have integrity amongst practitioners, amongst judges, amongst arbitrators. And we can go on about integrity. I've got other examples, but this important point is made in the amendments, the 2025 amendments about disclosure, and it codifies the common law. Whenever anyone is approached to become an arbitrator, they must disclose circumstances that may give rise to justifiable doubts about their impartiality, and to err is the side of caution. I had a case, I was a sole arbitrator. A friend of mine who happened to be a pupil in a set of chambers was offered a tenant, became a permanent member. I was in the middle of the arbitration. I immediately wrote to the parties and I said, this is somebody who I know. This is somebody who I've mentored. I have nothing to, but you must know about it. But it's all those sorts of disclosures. As Mr. Justice Mubiru said, by the way, in ATC, there's a continuing duty to give disclosure. And that duty does not end until you end the arbitration. So enforcement has its issues. Some of them are behavioral. No. Thank you.
Thank you so much. Thank you so much, Mr. Alika. Quite a number of insightful stories, but I think really for me, my takeaway is that without integrity, we're building our house on sand. Yes. So Barbara, just to come back to you, in your work, you've done a lot of work with justice institutions. I see you have done work in access to justice and efficient dispute resolution mechanisms and bringing it all together. From your perspective, and I know you work with one of the big non-government organizations, how do these gaps, some of which we have highlighted to do with enforcement, we've highlighted some gaps to do with, of course, integrity, Philip has just mentioned. There are some gaps to do with, of course, the text itself. How do these affect the people who are looking for justice, the people who actually seek out arbitration as a mode of dispute resolution?
Thank you, Jeffrey. And IDLO is actually an intergovernmental organization that is treaty-based, and we have 40 member countries. So for an organization that seeks to create the culture of law or culture of justice, you can already tell the direction that I'm heading. For us, clarity in laws is important because laws and institutions are drafted so that they can work for the people. So not just your big corporates, but also the MSMEs, your mama mboga, your shop owner, everyone who has a business interest is able to access any dispute resolution mechanism that they wish to access. And there is need for us to build institutions and to have legal framework that is clear, institutions that people have trust in and are confident about. So it's not just about access only, but thinking about it in terms of how do we ensure that these systems promote trust, people have confidence in them, they can be accessible, they are fair, and they actually provide affordable and effective dispute resolution mechanism. So that is very important to IDLO. And just thinking about the reforms that had been recommended by the Law Reform Commission, they were aimed at doing that. And some of the emerging trends that we are seeing in the world today that interestingly, we have failed to discuss and should have actually been part of the discussion is on third-party funding. Whereas there's a lot of gray areas in third-party funding, it does come to facilitate those who otherwise would not be able to participate in arbitration processes. We say arbitration ideally is cost-friendly, is fast, but there's also the other side of it where it is quite expensive for the ordinary justice seekers, and it can also be very technical for them. So they do need financial support to be able to meaningfully participate in arbitration processes. And when you're thinking about especially the SMEs and small enterprise owners and local entrepreneurs, you really need to think about not just arbitration, but even the other dispute resolution mechanisms. How do we make it clear for them to be able to access? So majority of the times when we talk of arbitration, we look at it from a perspective of the large corporates and the corporates that can pay. But it's about time we think about what about third-party funding for such forums, and for parties who participate in this, the practitioners, how do we ensure that there is actual consideration in terms of reduction of costs when you notice that the justice seekers before you cannot afford your fees? I can tell you for a fact that for some of the arbitrators, majority of them, their costs are not below 250 USD an hour. So if that is the case, when we look at the normal justice seeker, can they be able to afford that if it is per hour? And you're thinking about a case that would take maybe about 60 to 300 hours. So it's important that we consider mechanisms that can facilitate the use of these dispute resolution models by people who otherwise would be limited from accessing them. And I think where the framework is unclear, then ordinary users who would have otherwise opted for arbitration would be forced into repeated court processes. And we all know that currently the court procedures are not that friendly either, because they could be they could be very far from the parties who are seeking justice. They could also be quite technical for them, and it is difficult to see how small and micro SMEs can absorb the costs of having to deal with the complicated processes. And we know that arbitration, if applied well, is very practical in terms of resolving the disputes and can be very effective and therefore very cost-friendly for such parties. So for IDLO, for IDLO, then the reform is to look at how we would change the legal framework to make it more accessible, easier to understand, have model clauses that are fit for purpose, have fees that are predictable, because sometimes you cannot tell the arbitrator fees until you have engaged them. If it is ad hoc, if it is institutional, then the fees are included in the schedule. But even for institutional, have, for example, proper mechanisms that can be applied. Make it possible for them to have expedited procedures to address any emerging issue, and to look at it from a futuristic perspective. We are all moving towards transactions. Everything in our lives is sort of like in the metaverse. So how do we facilitate people who are suffering from the digital divide to be part and parcel of this movement or this reform that is going to be, I think, even designed in a manner that can be very exclusive to the justice seekers who do not have those funds to facilitate their participation. Something else that we should also consider, and I know Alike has made this very clear in his submission, is the ethics and standards for arbitrators and practitioners, but also for counsel. How do we ensure that in our legal reform, we make it clear that because we know that this is a practice where we are, nowadays it's called third hatting. It used to be double hatting, but now we are third hatting, because you could be the arbitrator, you could be the counsel, or you could even be the expert. How do we make sure that this is transparent to the users? How do we make sure that it is easy to tell? Disclosure is made mandatory, just like the English Act has done, and how to ensure that enforcement pathways specifically for the SMEs are made very clear, very easy, and very predictable, and that the court support mechanism would not be used to frustrate the access to justice after an arbitration process. That would be how I see it from an IDLO perspective, Jeffrey.
Thank you very much, Barbara. I loved your answer. And before I come back to Philip, I'm coming back to you on the same issue, actually. You mentioned something about third-party funding, which I know is a very dicey topic around Africa. There are arguments that have been made against. I don't know what you think about those issues, like conflict of interest. Of course, there'll be issues of increased influence in arbitration, confidentiality issues will be affected. So given that pushback against third-party funding, where do you think the ball lies? What is a neutral and a more feasible place to land? And Philip, I'm coming to you with exactly that question immediately after.
Transparency. It is not, it's not the answer to all the problems that third-party funding has, but transparency would start it. I think making it clear when you're being funded by a third party, it should be mandatory. Who the third-party funders are, it should also be mandatory. And then if there is any benefit that they would accrue from the award that is issued, that should also be disclosed. That is how I would basically put it. I think if we are able to address those, we can be able to move away from the challenges of third-party funding. Because when you look at it from our lens as common law, we are looking at it from the rule of champati, where you should not benefit from the proceeds of a case that you have been entrusted with. So I would leave it at that and leave Philip to take on the other disadvantages that third-party funding has. Over to you, Philip.
Yes, Philip,
Yeah.
You have the same hard question.
Yeah, well, thank you, Jeffrey. And I think that Barbara has dealt with it very well. I think that it has to be disclosure. I mean, this is a subject that has engaged us in Working Group 3 for some time, the extent to which parties should be obligated. And what nations, what states are trying to do is they're trying to develop a consensus around the extent to which disclosure should be made. But it just seems to me fundamental that if you've got some party that is investing in a case and has, so to speak, skin in the game, has money to earn, that because they have a vested interest, they need to be, we need to know about them. You see, the third-party funder can direct what happens in the arbitration or in the litigation, which counsel is appointed or which counsel they have a preference to, what evidence is called, whether they continue to fund. All of these things are relevant. And in my view, it seems to me that there should just simply be full disclosure in relation to third-party funding. But Jeffrey, I wanted to know if you just want me just to come back on some of the points that really good points.
Sure. I think you can. We have 2 minutes to spare.
Yeah, I agree that Barbara is absolutely right in terms of the legislation. We need to think not just about people at the top of the tree, so to speak, the corporates dealing with arbitration, but also have legislation that deals with people at the bottom. And we have to think about it as in a continuum. I mean, in Europe, it's really interesting. Small claims dealt with small claims, but there are also a lot of industry promoted dispute resolution schemes that deal with issues arising in banking, issues arising in insurance. You've got the financial ombudsman scheme in South Africa. You have the a banking ombudsman service. And we need to think about how we sort of replicate and follow that through. But we also have to think about this in the context of cross-border. You know, now you can send money from your Momo account to your M-Pesa account. You can buy something in Kenya. You can send it to Tanzania. And we're going to have all these issues that arise out of these cross-border transactions. And because of that, you have this question, for example, of the applicable law. If you're having an online transaction, which is the law applicable? And it comes back to the point that we were talking about the substantive law, the law of the arbitration agreement. But what I'm really talking about here is I'm talking about rules to determine which is the applicable law in Europe. For example, as part of the European Union, they develop rules for determining which law applied to which disputes, because parties don't think about which law is happening. If you have an Irish person dealing with a German and they don't know. So there are rules that and we in Africa, as part of the African Union, as a part of the continental free trade, need to think about actually a cohesive set of rules that will help us all to understand how we all fit together. Which court, which jurisdiction has priority and precedence in each place. Now I know that that some of these provisions of applicable law don't apply to arbitration. There's a specific exclusion. There's exclusion under Hague Convention. There's an exclusion under Rome I and Rome II. These are complicated technical issues, but we need to think about that so that we have something that is cohesive, that's predictable, that people understand, that the lawyers understand, and that doesn't get complicated. I mean, all of us know as lawyers, some of the most simple cases involving, the sale of a packet of cigarettes can involve the most difficult legal questions that get to the Supreme Court. But we need to think about that. Yeah. So those are the few points that I think I wish to add. Thank you. Thank you.
Thank you so much for that very insightful discussion, especially when you take it from a broader view for Uganda. But from your perspective, these are two very different jurisdictions. Philip, you will agree in terms of course, the financial ability. You've mentioned that the UK legal system is a $10 billion industry. I don't know if Ugandan industry makes even $1 billion, frankly. So how much of this is truly exportable from the UK to Uganda? Because we don't want to find ourselves in a situation like, maybe I can tell you, our Companies Act, after the UK amended their Companies Act around 2010, very many provisions of the Companies Act were copied and pasted. Parts of Table A, Table F, there was really no effort put in. So without adopting a copy and paste strategy, which of these provisions do you think we can actually export in their current form that can apply for Uganda?
So
Barbara, I'm going to come to you as well with that question.
you say you export. I say you export. You mean import rather than export, or
Yes,
where
yes.
I know
Okay,
I'm in London. I know
you're
I'm in
in
London.
UK, yeah. So for you, it's export.
Exactly. Yeah. So
Yes.
I mean, yeah. I just think we need to start again, and I don't think we should. We really need. I mean, okay, you can use the UK legislation as a blueprint, and when you think about it, the person who designed the UK legislation is an eminent barrister called Toby Landau, who went to Mauritius. And when Mauritius was making a big play for arbitration work in Africa, it got him to do the Mauritius Arbitration Act. And he also did the one in Abu Dhabi. And I think he's done others in other countries. So, and all of them, if you look at all of them, many of them are modeled on the English Act, because of course the author is the same. If you look at Ghana was very similar. If you look at Tanzania is a complete cut and paste of the English Act. I mean, Tanzania has just gone the whole way. They've not tried to reinvent the wheel. They've just done what the English have done with a few changes. But Ghana followed a similar way, but then decided that they would try and improvise. But I do think it's worth us just trying again to work through what it is that we want to do, and speaking to some of the English detractors, for example, to work out what changes people in the British jurisdiction are urging, so that we're not behind the curve, so that we don't spend this time and effort bringing our legislation, say, up to English standards, and then finding, or UK standards, and then finding that actually it's still lagging behind where we would want to be, because it just takes forever in Uganda to get the legislation. So I'm not in favor of saying any particular provision should be imported or exported. I mean, if you were to say to me now, what would you do? I would say adopt the English Act, because I think it's a decent act. No, I do. I think Tanzania's adopted it. I think Mauritius, as I say, and it's the UNCITRAL model law. It's standard. Kenya's also adopted quite a lot of the amendments of the English Act, but we are fundamentally behind. And so I'm not going to be drawn on which provision. I just think we need a root and branch replacement. I don't accept that we should be amending. I think we should be starting again.
Barbara?
I mean, what more can I say? He said it all. We do need to have a fit for purpose Ugandan lens developed in drafting the Arbitration Act for Uganda. And I'm calling it Arbitration Act deliberately, because I think we also need to sit down and ask ourselves, was it worth it having an Arbitration and Conciliation Act together and not have a mediation act instead? Do we need, looking at the whole ADR ecosystem and determining what laws do we actually need? And I think with the ADR policy now enacted, it gives us a good grounding, so we can now start the journey, or rather continue with the journey of reforms that was partially started by the Law Reform Commission, and ask ourselves, what would make arbitration in Uganda trusted? What would make arbitration in Uganda, arbitration users in Uganda confident about the process? What would make arbitration in Uganda effective as a dispute resolution model? So for me, if we do that, I think then we'll be able to say we can learn lessons from here. We can learn lessons from here, from the different regional experiences that we have seen, or international experiences, and then from there curate our own personal legal framework that suits the kinds of disputes we believe should be determined by arbitration in Uganda, and find a way of improving Uganda's attractiveness as a destination where enforcement of contract is predictable and credible. So that would be my view. Thank you, Jeffrey.
Thank you very much, Barbara. So I wanted to ask which African countries we can borrow from, but I think Philip and you have hinted on them. I quote Mauritius. I also quote Ghana. Tanzania. I don't know if I've missed out any that you think.
Nigeria, possibly. Nigeria.
Or Nigeria as well? Okay,
Yeah.
so
But,
yes, I know Nigeria did a few amendments recently.
Can I just say that on the Mauritius question, I mean, Mauritius took a really interesting approach because the appeals on arbitration, on enforcement, and Jeffrey, you asked me about arbitration, the appeals on enforcement in Mauritius actually come to the Privy Council. So Mauritius took the view that because there was there may be amongst investors a concern about the integrity of the courts. Now, I'm not saying that there is, just in case. They took the view that the Privy Council in England, which comprises UK judges, was what they should have as the final court of appeal. And actually, it actually works in the sense that, you know, English judges are excellent and they're above and beyond reproach. I'm not suggesting for a moment that Uganda adopts the appeals to the Privy Council. I'm not saying that at all. But I do think we need to think really carefully as a continent about potentially having an appeal court that is supranational. Now, I know in Working Group 3, there's a discussion about a multilateral court. And that, I think, is what is, because you're even European, you know, let me just say to you that when after my experience in the in that case in a country which we won't mention, I was sitting in the UN and I raised, the next point of business came up, and I raised the question of a code of conduct for judges, for lawyers, and for arbitrators. And it was almost me venting my anger. Do you know that it was supported by Mexico, by Chile, I think it was Japan, and the whole room was in favor. And I realized in that instant that this question of integrity and corruption is not something that is actually limited to Africa, but is actually a worldwide concern. And it was on that basis that the working group actually decided that they would adopt the work of the working group to be a code of conduct. So Uganda proposed, and it was accepted by the state members of the UNSTRAL working group, a code of conduct. And what we saw was ICSID developing a code of conduct, and UNCITRAL developing a code of conduct for both neutrals and arbitrators. And you know, it was published, I think it was last year or 2024. But that was Uganda, that was us recommending. And although it doesn't apply to local judges, which was the source of the problem, it does provide an example of how we can contribute to that international debate, but also how we should be working with our international partners to try to support the system of law that we have within Uganda. And for example, the multilateral court, everybody was saying, oh, we don't want a multilateral court because we don't want another ICC, you know? We don't want our leaders to be taken to ICC, or people are afraid of what might be the consequences, is the unintended consequences of these treaties. But that there, in my view, is a reason why those that understand should be involved and give advice, and we should support. But I say no more. Thank you.
Thank you so much, Philip. Barbara, is there anything you would like to add?
No, Philip has mentioned the work of the Working Group 3, which I find to be very informative. And it's a space for us to all just sit and keep monitoring, especially in terms of how reforms in investor-state dispute resolution mechanisms are being applied. And now even in terms of mediation, how mediation is being worked out. So I think globally, we have lessons to learn, but just like I said, we do need to have a fit-for-purpose arbitration act that answers the Ugandan question first. And we cannot look at other jurisdictions solely to copy and paste, because then it would not work for us. Back to you, Jeff.
Thank you very much, Barbara. So now, fly on the wall moment. If you're in the room, you're advising the drafters of the bill today, and you're given the chance. What are your top recommendations? Top three recommendations.
Is that to me or to Philip?
I think you can go first, both of you.
I think first and foremost is CADA.
Agree.
First and foremost is CADA. Can we
That
determine?
seems like a universally accepted point.
Yeah, I think it's important that we determine where we are going with that, and there are very many lessons to learn about institutions that have been adopted. Then the other would be what we've just spoken about: integrity, ethics, and codes of conduct. How do we provide the legal basis for the integrity of the practitioners, not just the arbitrators, but the council and the experts, so that we can promote transparency and confidence of the users of arbitration services. And I think for me, what is the other lesson that I would like them to address is specifically from the stakeholders consultations that ULRC had. I think for them, they wanted something that dealt with procedural efficiency. So just understanding how do we approach the court? When do we approach the court? England has introduced the emergency arbitrator proceedings. They have also introduced a clarification on the seat and the jurisdiction challenges, because this improve on procedural efficiency. How can we do that? And how do we strengthen the position of Uganda as a seat of arbitration? Because that ultimately is the goal, that Uganda emerges as the preferred seat of arbitration in Africa. I say that tongue in cheek because, of course, if you ask me, I have allegiance elsewhere, but I do think that Uganda has potential. Back to you, Jeffrey.
Thank you very much for the honesty. So yes, Philip, top 3 recommendations that you would give to the drafters of the bill.
Well, I agree completely with Barbara's number 1 point that CADA needs to be consigned to history. The sooner that happens, the better. I think that even with RAPEX and taking CADA in-house does not cure anything. I was looking actually at the questions that were raised by Constant Odeke, and it was this question of the changes that were introduced. We need to have an independent. I mean, it's the courts. The courts are aware decisions about challenges and supporting for the arbitral process. So it's pro-arbitration. The arbitrator is dealing with everything, but if there's a dispute, then that is something that should be decided by the courts. That is the first thing. What I do think that we do need in the legislation is we do need teeth. We need teeth that actually applies to conduct. And I've suggested this. Actually, we're looking at the amendment of the rules to the London Court of International Arbitration, and I've actually suggested this, but it was the point that I made in relation to proposing the code of conduct. When somebody behaves badly, either as an arbitrator or as counsel, you can report them to their professional body. But the problem with that is that sometimes these professional bodies don't do anything. Lord Mance, the British law lord, former Supreme Court judge, I think he's former Supreme Court judge, forgive me if he's still sitting, but he proposed an amendment to the 2025 legislation in England that if there's corruption, this was after PNID in Nigeria, the big case where those British lawyers and Irish lawyers were going to make off like bandits with billions out of this fictitious case, that if the arbitrator detects corruption, that it should be reported to the country involved. But the problem with the country reporting it to the country involved is if you have people in the country who are not interested in enforcing, and I will say no more than that, then of course it amounts to absolutely nothing and it doesn't help. So it seems to me, though, it would really be helpful if we had an open, transparent way of disciplining and instilling discipline in those that are involved in arbitration. In the case that I mentioned to you, the lawyer who was responsible for that judgment, and I'm sure it was a lawyer who wrote the judgment. You don't copy 3,500 words and get a judge referring to himself as the learned judge and expect us to believe. But I was going to report him to the Chartered Institute of Arbitrators because that was a professional conduct issue. I was the arbitrator, he was counsel. I mean, if I had reported him to his local counsel, I'd still be waiting now. Sadly for him, he died before I could make the complaint. So that was that. But we have to have some way of policing conduct, because it is not acceptable. And I also think from the point of the consumer. I mean, even amongst arbitrators, you get this issue. I've heard it said about arbitrators, and if there's no confidence in the arbitrators are like judges. You know, if you don't have any confidence in the arbitrators, then what is the point? You know, you'd rather go off and take your chances in front of a judge. And actually, you know, this question about judicial integrity is not a secret. I mean, how many times have we heard the president? I heard the president of Uganda, His Excellency, speaking about the retiring Chief Justice and saying how he had never heard anything said about that judge being involved in anything improper. I mean, the president of the country is standing up in a public forum talking about the complaints that come to him about judicial integrity. So this is not a secret, but it's something that we all have to deal with. Because if we don't deal with it, what is our independence worth? What does it matter if we keep looking to England to borrow from England? We're never going to get anywhere. I mean, if people don't want to actually accept their civic responsibility to do what they expect of themselves, so that they know when they go to somebody to have their dispute adjudicated on, they're going to get their dispute, we're wasting our time, colleagues. We're wasting our time. I don't think I have a third one. I think those are my biggest one. My biggest is integrity. We need to get it right. We need to get it right. Thank you.
I'm glad that you've answered the question of Mr. Deke in the chat.
Yes.
But there's also been another question by Abdul Hafiz Lutalo.
Yes.
And he says costs. Could
Yes.
the panelists please address us on the lacuna in the determination of costs by the tribunal, whether it should be limited to being done through an additional award if not handled during the arbitration? Philip, you can take that first. I'll get Barbara.
So thank you for that question. I mean, it's interesting. I have had a debate amongst practitioners, both in Kenya and Uganda, where colleagues actually believe that costs are to be determined in accordance with the Advocates Act and the Advocates Remuneration Act and relevant acts. But in fact, the UNCITRAL model law is quite clear on this. Costs are a matter for the tribunal, and there's the cost schedules and the cost rules, sorry, in court do not actually apply. I know there's a recent authority in Uganda in relation to what the position is in the event of a decision not being made. I can't remember the name of the case, but I know that I've seen it and I've read it. But costs are a matter for the tribunal. The costs are the costs of the litigation costs. That's the party's own costs and the costs of the arbitration. Just on this one point of arbitrators' costs, I think it's really important for an arbitrator to record his or her costs and the time that they spend on a case with precision. And I have seen cases where this has not happened. And this is something that is not necessarily transparent to the parties, but it's a debate that I hear, it's a discussion that I hear. I hear murmurings about parties complaining about arbitrators and their costs and parties not accounting for costs. It's absolutely essential that the parties are able to know exactly what work has been done and what the charge is for. And that seems to me to be the only real check on costs. I don't think there's anything else that I can add to that. We've dealt with the question of third party costs. I think that's it. Thank you. Thanks.
Yes, Barbara, the question of costs. Abdul Hafiz Lutalo has asked a question on the lacuna in determination of costs by the tribunal and whether it should be limited to being done through an additional award.
Oh, sorry, beg your pardon. Yeah. Sorry, can I just come back on that question? It doesn't matter actually. You can do it as part of the award or an additional award. Sorry, I beg your pardon. I didn't deal with that. Yeah, thanks. Sorry.
Yes, Barbara.
Maybe I would say there are skills to manage costs, and this depends on the parties actually. And yes, an additional award can clarify the costs of the tribunal, but I think progressively what I've seen and in the cases that I've had the opportunity of being party to, majority of the time, arbitration becomes expensive because parties and tribunals allow the process to drift, and parties overplead, either over document, or we even begin to litigate procedural issues. So basically turning the arbitration, the tribunal into a court. So it is possible to actually limit costs as a skill within the arbitration process. So you can do this by agreeing on the costs of the tribunal even before your procedural order number 1. Some of the issues you could include there would be how the costing would be done for the tribunal so that you can manage it. Because if you do not put a cap, for example, on what could be recoverable costs, then this is left to the tribunal to determine, and the tribunal will determine as it pleases or as you have pleaded. So it's essentially very important that we do early planning. We integrate planning in that. We make sure that it is clear that there is proportionality, ask for transparency, just like Philip has said. Check what the arbitrator is charging you for, because 90% of the times we are not even looking at the fees that have been charged by the arbitrator. Was it true that you actually sat in an arbitration process at this time? If there are this many documents, sometimes they overcharge on the hours. So it becomes easier when you plan, you ensure that there is some form of proportionality. You are active in the tribunal management. You don't need to have every witness appear, for example. You don't need to have every document submitted for verification at the arbitration process, especially if you have agreed on them. So finding ways that you are active in the tribunal management and there is early planning of the costs. If you can cap them, I always recommend to cap, where possible, include, if you can do documents only, do that, but also there is a question of how much time the arbitrator will take in reviewing the documents. If it is, you can limit the hearing processes, virtual hearings. These are some of the tactics you can use to reduce on the costs of arbitration. Please, if it is not something that needs a whole panel, choose one tribunal member. You only need a sole arbitrator for majority of the disputes that we have. That also reduces the costs. But I think cost management is a tactic for the lawyers, and it should be something that they endeavor to do at the beginning of the tribunal process rather than at the end. And then that reduces how much, if it has to be through an additional award, how much the tribunal can charge as costs.
Thank you so much for that very detailed response, Barbara. I only have one last question for both of you. Philip, you have something to add?
I was just going to say to Barbara, not to be cantankerous, but I as an arbitrator don't like my cost capped for the very reason that the minute you cap your costs, counsel knows that they can do and say anything, and the costs will never reach. And if they want to drag out the proceedings and behave unreasonable, you're stuck. And having the costs is an incentive. I know it's counterintuitive, but it's an incentive for the parties to behave. The minute you cap, you're finished, I think, in most cases. Thanks.
Clearly a topic for another day. I think
yes,
being a state council, I'm always interested in capping costs.
Yeah.
Former state council, capping costs and managing costs. Otherwise, government would be left with a huge bill to pay.
Yeah.
So it goes back to how the tribunal controls the process and makes sure that counsel are called to order. And just counsel understanding that arbitration proceedings are not court proceedings. You do not need to reiterate every other single point, object to every issue. But then again, as I say, this is a topic for another day. We could go on forever.
But can I just say also, just by way of follow-up and rejoinder, now that we've got summary judgment and greater control over proceedings, it may be possible, if parties are playing along and allow for summary determination, then it makes more sense.
Yeah, but that's in England. It's not happening.
No, I understand. You can always, You
Thank
can
you
always
so
agree.
much.
Thanks.
Yes. So just one last question. What does success look like for Uganda as a seat of arbitration with all these changes, with the proposed amendments? We have seen we've seen a number of African jurisdictions have taken positive steps. So for Uganda, what are we aiming for? What can we consider to have been a successful arbitration, or as a seat of arbitration, one that is attractive and brings on foreign investment and people can trust it? What does that look like from your perspective?
Jeffrey,
I'm going to start with Barbara.
I think that the answer is in your question. When Uganda is seen as a seat for arbitration, then we have been successful. I mean, and you can tell that there is confidence, there is enforceability of awards without question, there is predictability, and the confidence of the users. Then we are successful as Uganda. And if we can be able to showcase in terms of business tourism, the number of people flying in just to do the arbitrations in Uganda, or having the arbitrations being recognized and enforced in Uganda because of the legal framework, then we would have succeeded.
Thank you very much. Philip?
Thank you very much indeed, Jeffrey. A success for me is exactly what Barbara has said. We've got lots of really good, competent lawyers in Uganda, and we've got competent judges. We're great people, actually, incredibly nice people, and we've got a wonderful, wonderful climate. I always say, where would you rather have an arbitration? In Kampala or in London in the middle of the winter? There's no question. I mean, this is one of the things that actually Mauritius was trying to capitalize on as a venue. I remember doing an international arbitration that involved the Kampala Northern Bypass. And we brought in our 3 international rockstar arbitrators. And they arrived at Entebbe. And by the way, it was just after the end of the Ebola. There was the first Ebola. This was 2012. We had an Ebola and we were counting the days. And we got out 21 days. But when they arrived at the Serena Hotel and they were taken to their executive suites and they saw this place, their eyes were popping out of their head. The witnesses couldn't believe. I mean, we have a beautiful place to host and entertain international. This is international arbitration now. So, we had data rooms, we had copying, we had all the support services that were needed. And in this particular case, because it was a European Union funded arbitration agreement, the seat was Uganda. But there's so much more of that we can do. But we need to have the infrastructure and the support and the culture. We need to replicate what England has done in terms of integrity all around and service. If we do that, we will win hands down every time. We will share it with Kenya, and we'll share it with Tanzania, and we'll share it with Rwanda. But we're okay. We can do these things, but we've got to think about what we want to do. So for me, it's a work in progress. We've got a long way to go, but it's entirely possible if we set our minds to it.
Certainly. You seem quite positive for someone who has had so many bad experiences.
You have to be. You have to be positive. You have to be positive about where we're going. I mean, Wananchi, the people we are lawyers. People forget that the law is vocational. Even as an arbitrator, we are providing a service for the resolution of disputes. We're providing a service to the international community. We want to be able to stand with our peers in London, in New York, in Paris. We want them to respect us. instead they sort of stand there and they look at us and they think, but you guys, you've got a problem in your system and, there's integrity issues. We don't have to deal with that. Why should we deal with that? Anyway, that's
I totally agree. I totally agree. So we've had a few running questions in the chat. I saw there was a question by Abdul Hafiz, which was answered. He has asked another question. There is also a comment. I believe it's a comment. I don't know if it's a question. Mr. Olive Zale Otete, he has said, thank you, Philip and Barbara, for the insights. In my view, there is consensus that we need a comprehensive arbitration act to replace the current Arbitration and Conciliation Act.
Yes.
The real work is how arbitration stakeholders in Uganda, including SIAB, the Uganda chapter, CADA, ICAMEC, and others, can work together to influence the redrafting of a comprehensive law by the relevant government institution. I believe that's a comment, and we entirely agree. Thank you very much, Olive Zale Otete, for your comment. There is one last question here that was brought by Abdul Hafiz. So Abdul Hafiz is asking, it's tied to his first question. He says, my question, no, this is the first question. His second question is a follow-up to the first one. And he says, just to contribute to the last question, there is an emergency of having only 2 appointing authorities in Uganda. Maybe Miss Barbara could convince the minister to approve many more to deal with our issues. I think that's also a comment to Barbara. But he makes a valid point that we only have 2 appointing authorities in Uganda. I believe it is now 1, just ICAMEC. And we really need to fill that gap as well. So there, I do not see any other questions in the group chat or in the webinar chat. I think we can now move to closing remarks because Philip started. I asked a question. Ernest, I can't see your question in the chat, unfortunately. I think you sent it directly to SIAB. Ernest, I've seen it. Ernest's question is, my question to the panelists is on setting aside. The England threshold is serious irregularity causing substantial harm under Section 68(2). Section 34 of the Uganda Act is silent on this threshold, and most court decisions refer to England cases when determining the applications. Does this call for reform, or would legislating the threshold limit the interpretation of the grounds? I think, Philip, you're best suited for answering that.
Yeah,
I don't know what you're using.
Yeah, I saw that actually, and I did see that because you've got the provisions that are under the New York Convention, which are under Section 103 of the English Act. Those replicate the various articles of the New York Convention. But then under the English Act, you've got Section 67, Section 68 and 69, and Section 67 deals with the jurisdictional objection. And it's just, I suppose, I mean, we could, I mean, we've got Section 38 under the ACA, which contemplates a potential appeal where it's been agreed. And I think under that, you can probably have a case stated as well, if I'm correct, in terms of reviewing the decision, but it has to be something that's agreed. And I think, if I'm right, I haven't looked at the Act, it only applies to domestic rather than international. I'm just having a quick look at the Act. But whether or not it should be accepted, I think, frankly, if there has been a serious procedural irregularity, then you can challenge, and that is only appropriate. I don't see any difficulty at all. I think that's wholly consistent with the New York Convention. I'm just looking at Section 38 of the Act. I think this is right, and it probably only applies in domestic arbitration, Section 38, which is a question of law arising in domestic arbitration, which would include jurisdictional issues under Section 38. Sorry, which would probably include jurisdictional challenges replicating Section 67 under the English Act, but you have to specifically agree for it. Whereas in England, it's a standing provision that you would bring yourself within. But of course, subject also to the usual restrictions of going back to the tribunal and asking the tribunal to revisit questions of jurisdictional excess.
I
So,
wonder,
go
Philip,
on.
he mentioned
Thank
section
you.
34, actually, not 38, where you can set aside on grounds of incapacity, invalid arbitration.
Sorry, Barbara. Section 34 though replicates section 105. It's the New York Convention grounds for setting aside.
Yes.
So
Yes.
that's one set. Those are also recognized under the English Act. But section 67 is a separate appeal based on serious irregularity.
Indeed, and for that, I think
Sorry,
you need.
Sorry, go on.
I'm not sure we actually need a reform for that to be specifically upheld by the court, because then you could always argue it under if you're looking at it from a public policy perspective, you can raise that if there's serious irregularity, because then the question would be that it challenges reinforcing the arbitral finality. But if you're looking at it from an appeal perspective, then for the appeals, then the law is quite clear in Uganda that it applies to domestic arbitrations, not
Absolutely
international
right.
arbitrations.
Yeah.
So for domestic arbitrations, then the procedure is well set out, and you would have to follow through with the processes that have been articulated in the Act for that purpose.
Yeah.
So I'm not sure whether there is need for that, because you need to show material prejudice, substantial injustice, which there is provision for you to do so. So there is no need for the law to expressly say it, because laws are purposefully interpreted, in my view. There is no need for specific provision for every other thing that we think can come out.
Yeah.
So at the moment, the law as it is can be purposefully applied to address serious irregularity causing substantial injustice, in my view.
Yeah. Can I just say that we need to make sure we get this right? Section 67 deals with jurisdiction. And I think that was his question. I made the mistake in saying procedural irregularity, but Section 67 under the English Act is substantive jurisdiction. 68 is serious irregularity.
That's true.
And so I think we need to be clear about that. But I think both provisions though, both provisions are in a way, if you look at section 105, that the arbitral proceedings were not in accordance with the agreed procedure is a way to get in. I'm just looking for section 105.
Sure.
He's asking us, 103. So, under, for example, 103D, which is similar to 34, that the award deals with a difference not contemplated or not falling within the terms of the submission, which is a question which goes to jurisdiction specifically. So, Section 34, in fact, provides for, in a way, a jurisdictional challenge. But what one has to do is effectively wait until the end. Do you see, till enforcement of the award? You can't challenge jurisdiction otherwise, in the way that you can under the English Act. Yeah.
I think that's certainly a ground. That's certainly a ground for review, and I hope some of the drafters are on the call. I saw one or two. So just before we end, I think our attendees would like just a few closing remarks from both our panelists, our very eminent panelists who have spent 2 hours here with us. Philip started, so I think Barbara can start the end.
So it's not the end of the journey, clearly. These discussions should now move to the tables that need to progress this particular discussion, because this conversation is not new to Uganda. So I think it is a question of how do we congregate, put into paper our thoughts, and present them together to the Ministry of Justice and Constitutional Affairs and the Office of the Attorney General, and maybe even to the Chief Justice, because then the kinds of decisions that are coming out of the commercial court do require reflection, especially on the kinds of reforms that are going on globally. So for me, it's just to say, the struggle continues, whether it is a struggle and we will see at the end of the day, but let's continue, but more purposefully. So I think previously the Deputy Solicitor General did indicate that he's willing to receive feedback from practitioners. Let's get that done. Let's sit down with him. Let's engage the First Parliamentary Council. Let's engage the Minister for Justice and move this forward. There's no better time than now. Uganda is Uganda is going to be a leader in oil and gas in the region within East Africa and Central Africa. We have very vast minerals to be exploited in Uganda. So it is about time we take our place in Africa. The CFTA sets the pace for us. It's about time. So we do need to pick up our pace and get things done. Hopefully, give ourselves a timeline of the next 2 years. We should have a new legislative ecosystem that promotes the use of the different dispute resolution mechanisms. Thank you, Jeffrey, and thank you for having me. It's been a pleasure.
Thank you so much, Barbara, for your lovely contribution to this discussion. Yes, Philip, you have the floor.
Thank you very much, indeed, Jeffrey. It's been interesting, actually, looking at the provisions of the English legislation and looking for inspiration from England. But I do think we have to look for inspiration within ourselves for what we see as our way forward in the world of international arbitration. I mean, it's not all doom and gloom. And I can say to you that that Uganda was ahead of the curve, for example, in relation to the effect of conciliation awards. If you remember, the Ugandan ACA provides for a conciliation award to stand as an arbitral award. I mean, that is exactly what the Singapore Convention did. So Uganda has some really good things about it. I mean, there's some interesting points about if it wasn't an arbitration award, can it be treated as an as a New York Convention award? But all in all, I think we need to sit down as a group of stakeholders and just think through what we want to achieve, how we want to progress, and then draw from all the best and put together something that is fit for purpose, that can see us through into the foreseeable future, that focuses on people and transactions at the very, very bottom end of the sort of transactional frequency. In other words, you know, your Momo payments, your online payments, which are cross-border complex transactions, and also the big international arbitrations. And in that way, we will have something of which we can be really proud, and more people will have no hesitation in coming to arbitrate in Uganda. So yes, I think there's everything to look forward to, provided we're willing to take the responsibility and find a way forward with new legislation. I think it's got to be new legislation. But by the way, I mean, I say new legislation. Uganda is still based on the UNCITRAL model law. I mean, you know, it's not a non-UNCITRAL model law. It is an UNCITRAL model law country. So the new legislation wouldn't necessarily be just throwing everything out. It would just be reframing it, redrafting it, getting rid of CADA, dealing with the questions about, you know, jurisdiction and whether or not you should have a substantive section on jurisdictional challenges, whether or not you should have appeals, you know, some of the English provisions, a serious irregularity, points of law, you know, Section 38. So, you know, arbitrator immunity, you know, whether or not you should have costs against an arbitrator, the duties of the parties, the duties of the tribunal, the fairness, all of these things that can be incorporated into the act. But it's not difficult. It's not difficult at all. We can certainly do that. Thank you.
Thank you so much. What an enriching discussion. What a wonderful discussion. I am as informed as I am educated. Thank you so much, our lovely panelists. Thank you for taking off your afternoon to spend it with us. And I believe it has been a thoroughly enriching discussion for our participants and for everybody who attended. Thank you, everybody who has taken off time to attend this very wonderful and engaging webinar. We hope our panelists have answered your questions, and we hope at least you have got left here more informed about arbitration, the Uganda Act and the UK Act. Please, as the Chartered Institute of Arbitrators, there are several events that are lined up, and this is just one of them. But coming up, there are several events that have been put in place that you can join and be a part of to join the broader CIAB community. The Young Members Committee has organized a Connect event. It's going to be held at Onomo Restaurant. The link has also been shared for registration. The Young Members Committee also has an essay writing competition. So just look out for that. 31st August 2026, there's an essay writing competition organized by the members group. There is also an accelerated route for fellowship, which is going to begin on 21st September 2026. You can register for the accelerated route to fellowship. You know the requirements. But if you cannot register as an accelerated route for membership, for fellowship, you can register for the accelerated route to membership, which is happening on 11th November 2026. But not forgetting that in December, CIAB will also be having their end of year colloquium. So we also look forward to hosting you in that event. On my end, I am very grateful, and I would like to thank CIAB for the opportunity. I would like to thank the panelists for making this a very easy discussion to moderate, and for taking off time to give us well thought out and detailed responses to our questions. We do not take it lightly. Thank you so much for your time, and thank you to everyone who has made time to attend this webinar, and we look forward to having you in the future. Have a lovely evening.
Thank you very much indeed. All the best. Bye-bye.
Okay, everyone.
Bye.
Bye.
Bye, thank you.